Afternoon. I'm Kafuzi Jackson, the Deputy Attorney General. I was getting concerned about the gender composition of the committee. I was going to say it has an issue with human rights.
Good afternoon, Honorable Chairperson, Honorable Members. My name is Pius Wilivon Muha, Deputy Solicitor General. Thank you, sir.
Good afternoon. My name is Harriet Itiang, Assistant Commissioner, Ministry of Justice and Constitutional Affairs.
Honorable Chairperson, Honorable Members, my name is Christine Nabisawa. I'm a State Attorney at the Ministry of Justice and Constitutional Affairs.
Good afternoon, Chair and Honorable Members. My name is Nampuera Crispus, State Attorney, Ministry of Justice.
Honorable Kansime to introduce herself, and then you.
Thank you so much, Chair, and the Honorable Minister. Kansime Caroline, Member of Parliament, Ruchiga District. Thank you.
Thank you, Chair. One observation. The chair does not know the proper name of her member. She's Kamusime or Kansime. So now you want your guest to be the one to introduce your own children to you. Chair and colleagues, we appreciate the invitation.
On that note, you will give us another 1 minute for Honorable Charity Beina Babo to take a seat and introduce herself.
Thank you, Chair. I am Brigadier General Charity Beina Babo, one of the representatives of UPDF to the 11th Parliament, and I'm a member of this committee.
Thank you, Chair. I feel safe already. I appreciate your invitation to appear before this committee, and as it is the norm, we are required to do a form of accountability as regards human rights, how much is done, what steps we are taking, corrective measures, and otherwise. So we have a presentation which we want to share with the committee. I hope those are enough. There is a forwarding letter which is being received by the Office of the Clerk. We can provide more copies just in case you don't have enough. So as you share the copies, Chair and colleagues, members of Parliament, we intend to present a statement of our accountability as far as human rights is concerned. You wrote to us and set for us issues, and our statement is based on the issues that you forwarded to us. I'm going to request Mr. Pius Wilivonwa, our Deputy Solicitor General, to read our presentation.
Thank you.
Pius, hold on a minute. While Doug was making his comments, we were joined by Honorable Baka Stephen Mugabe. Yes, take a new seat.
You. Thank you, Chair. Baka Stephen Mugabe, Bukoli County, North Bujiri.
Thank you, Honorable Deputy Attorney General, Honorable Chairperson, Honorable Members. This is the presentation to the Standing Committee on Human Rights on the state of human rights in the country since January 2022 to date. It's prepared by the Honorable Deputy Attorney General, Kafuzi Jackson Karugaba. It's dated today, 6th March 2024, to the Parliament of Uganda. The presentation, I read it verbatim. The Chairperson, Committee on Human Rights, Honorable members of the Committee on Human Rights, ladies and gentlemen, I'd like to express my gratitude to you for inviting me to come and make a presentation on the state of human rights in the country since January 2022 to date. Honorable Chairperson, honorable members of the committee, I'll proceed to address you as hereunder. Introduction. Uganda is a constitutional democracy and a country governed by laws. Chapter 4 of the Constitution contains the Bill of Rights, which provides for the protection and promotion of fundamental rights and freedoms. The government of Uganda is committed to the meaningful realization of the rights of individuals. The committee is in line with the undertaking bestowed upon government by the National Objectives and Directive Principles of State Policy under Principle 5 of the 1995 Constitution. Principle 5 provides that the state shall guarantee and respect institutions which are charged by the state with responsibility for protecting and promoting human rights by providing them with adequate resources to function effectively. It is against this background that Uganda has experienced a progressive improvement in protecting and promoting human rights, notwithstanding the challenges. 2. State of human rights in the country since January 2022 to date. 2.1 Civic education and Article 52 of the Constitution. Article 52 of the Constitution, and in particular 52(1)(g), mandates the Uganda Human Rights Commission to formulate, implement and oversee programs intended to inculcate in the citizens of Uganda awareness of their civic responsibilities and an appreciation of their rights and obligations as free people. This is complemented by citizen empowerment programs by the Judicial Service Commission in accordance with Article 147(1)(c) of the Constitution. There has been success in the multidimensional approach to building public awareness of human rights through public debates and interactive media talk shows on human rights issues. The sustained public awareness on human rights standards and citizen responsibilities has progressively grown since 2022 from limited human rights mandated institutions of government to a broad responsibility involving non-state actors. Previously, the empowerment was physically done. However, it has now enhanced to online-based citizen empowerment activities due to the growing embrace of social media platforms and since the outbreak of COVID-19. The government, together with its institutions, in collaboration with private stakeholders and civil society organizations, carry out civic education to citizens among the population. The government has also undertaken the translation of the Constitution of Uganda into several indigenous languages, namely Runyankore Ruchiga, Runyoro Rutoro, Ruganda, Rufumbira, Ateso, Runyara, Leb Acholi, Leblango, Lusoga, Lumasaba, Lunyole, Lugwere, Aringati, Lugbarati, Maditi, Duadola, Dualur, Lukonzo, and Ngakaramajong. In addition to these, a translation was made in Kiswahili as a commonly used language. These translations represent 60% of the indigenous or native languages that are spoken in Uganda. There is also a Braille version of the Constitution to cater for citizens who are visually impaired. These translated copies have been disseminated to the relevant indigenous committees within Uganda. 2.2 The National Action Plan on Human Rights. The National Action Plan on Human Rights has been a recurring demand from international and regional human rights bodies, and this development is a result of a voluntary pledge by Uganda at its initial review under the Universal Periodic Review Mechanism. The relevance of the National Action Plan on Human Rights to Uganda is based on the country's human rights history, but more importantly, on the need to identify clear steps and timelines for improving the protection and promotion of human rights in the country. The draft National Action Plan on Human Rights provides a planning and coordination framework for facilitating the effective implementation of a comprehensive policy and legal framework for human rights matters, Sustainable Development Goals, the SDGs, and accepted recommendations from the Third Universal Periodic Review, the UPR3, with the goal of progressively entrenching a human rights culture in Uganda. The National Action Plan on Human Rights is yet to be approved by Cabinet. However, its implementation is ongoing through targeted activities and interventions by various government institutions within the overall framework of their specific mandates. This is backed by the National Development Plan 3, which references the NAPHR as a guiding document for implementation of government programs under a human rights-based approach. The Ministry of Justice and Constitutional Affairs is in the final stages of developing a National Action Plan on Human Rights, 2024-2027, which outlines strategies for promoting and protecting human rights, including measures to address discrimination and ensure equality before the law. One of the priority areas is to strengthen enforcement of laws against harmful cultural practices and creating awareness for cultural leaders. The Ministry of Justice and Constitutional Affairs, in finalizing the development of the National Action Plan on Human Rights, will additionally consult the Ministries of Internal Affairs, Ministry of Defense and Veteran Affairs, Office of the President, Ministry of Gender, Labour and Social Development, Ministry of Foreign Affairs, Ministry of Information, Technology and National Guidance, the National Resistance Movement Secretariat, among others, after which the NAPHR will be submitted for approval. Once Cabinet approval is obtained, the Ministry of Justice and Constitutional Affairs will engage the Ministry of Finance, Planning and Economic Development to provide funds for the implementation of the National Action Plan on Human Rights by all ministries, departments and agencies. 2.3. Access to justice. The government of Uganda embarked on the increase of the number of judicial officers, prosecutors, state attorneys, and human and high court circuits in order to reduce the workload, ensure timely disposal of cases, in order to increase the efficiency and effectiveness of the courts of law. On 4th July 2023, the number of High Court judges was increased from 83 to 151 judges by resolution of Parliament. The Judicial Amendment Act 2023, Act number 3 of 2023, increased the number of justices of the Court of Appeal from 15 to 35. There is ongoing construction of 2 High Court buildings in Rukunjiri and Soroti districts, construction of Alebtong, Liantonde, and Budaka Chief Magistrates Courts, Abim, Karenga, and Patongo courts, which are nearing completion. There was procurement of 51 vehicles for justices and judges, registrars and magistrates across the country in hard-to-reach areas to facilitate locus visits, inspection, and monitoring, among others. The judiciary has created 38 new High Court circuits in Apach, Bujiri, Bushenyi, Dokolo, Entebbe, Ibanda, Kasese, Kivoga, Kitgum, Kumi, Rugazi, Moyo, Nebi, Ntunga, Mupalisa, Patongo, Rakai, and Wakiso, among others. The Human Rights Commission is fully constituted following the appointment of 2 commissioners on 8th December 2022. The above measures will inevitably facilitate access to justice for all to create an enabling environment for the observance of human rights. 2.4. Prevention of torture. Article 24 of the Constitution prohibits subjecting any person to any form of torture or cruel, inhuman, or degrading treatment or punishment. Article 44A further makes this fundamental right non-derogable. The Prevention and Prohibition of Torture Act 2012 was enacted to give effect to Article 24 of the Constitution and to domesticate the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. The government also enacted the Prevention and Prohibition of Torture Regulations 2017 to operationalize the Act. The regulations provide a complaint and investigation procedure, among others. Security agencies have taken steps to ensure adherence to the Prevention and Prohibition of Torture Act 2012. The Uganda People's Defence Forces has a human rights training manual in place that has been integrated into the military training curriculum, and the Uganda Police Force passed a human rights policy to improve the operating framework and to strengthen the police officers' observance of human rights. The Uganda Prison Service Standing Orders 2017 incorporated the Prevention and Prohibition of Torture Act provisions, including prohibition and criminalization of torture. There is also use of technology through acquisition of modern equipment that aids investigations and interviews to ensure that the same are carried out in a manner that is compliant with international human rights standards. Surveillance tools among security agencies have also been installed to monitor the actions of the security personnel to eliminate torture as a method of extracting information during interviews. This has led to the reduction of torture allegations against security agencies as per the Human Rights Commission annual reports. His Excellency the President has publicly issued several directives to all security agencies with regard to zero tolerance to torture in the course of their duties. Additionally, a circular warning from the Inspector General of Police was issued to all police units in Uganda, warning that police officers will be personally held accountable for their torturous actions. This is in line with Section 10 of the Human Rights Enforcement Act of 2019. Other than the Human Rights Commission, there are external oversight mechanisms for monitoring and ensuring compliance of human rights, which include the Standing Committee on Human Rights, the Sectoral Committee on Defense and Internal Affairs, the Inspectorate of Government, and the Cabinet Standing Committee on Human Rights. In respect of Uganda Prison Services, Section 109 of the Prisons Act 2006 provides for visiting justices who carry out impromptu inspection of the detention facilities to monitor human rights observance, awareness, and adherence. The government of Uganda considers the recommendations of the Human Rights Commission and implements them to the greatest extent possible. Prohibition of torture. In order to enhance the capacity of security agencies to prevent acts of torture, UPDF, the UPF, Uganda Prison Services, in collaboration with the Uganda Human Rights Commission, civil society organizations such as African Center for Treatment of Torture Victims, Human Rights Center, Uganda, have continued to train officers on the use of non-coercive means of extracting information and on the provisions of the Prevention and Prohibition of Torture Act in order to prevent torture. Over 95% of the prison staff have undergone human rights training as one of the basic modules at the Prisons Academy and training schools. The Legal and Human Rights Department of the Uganda Prison Services visits the prison units regularly to sensitize the staff and prisoners on their human rights and obligations. A finding by the Human Rights Commission or court for a violation of the right to freedom from torture or cruel, inhuman, or degrading treatment, or punishment or violation of any other human right may attract an award of compensation against the perpetrator. Enforcement of human rights awards is often a protracted process that is subject to availability of funds for payment of awards. Government prioritizes human rights compensation awards. The Ministry of Justice and Constitutional Affairs follows up with the different ministries, departments, and agencies to ensure that tribunal and court awards are paid to the respective victims. For example, the Ministry of Defense has in place a compensation committee to ensure that awards to victims of human rights violations are paid on time and prioritizes payment of compensation awards related to human rights. There is also a dedicated desk at the Uganda Police Force to follow up on tribunal awards and ensure timely payments. The Uganda Human Rights Commission has an existing database that is used to track the implementation of human rights recommendations as well as awards. The human rights database is centrally accessed by most MDAs to track the implementation of human rights recommendations and awards. The Ministry of Justice and Constitutional Affairs is working closely with the Uganda Human Rights Commission to introduce and integrate into the human rights database all MDAs for ease of follow-up and tracking of tribunal awards. The payment of outstanding compensations by the Uganda Police Force is still low owing to limited budgetary allocations. The Uganda Police Force has, however, devised a number of strategies intended not only to settle payment claims, but also deter police officers from engaging in human rights violations in the course of duty. The strategies include invoking individual responsibility against violators to pay their awards to the victims in accordance with Section 10 of the Human Rights Enforcement Act 2019, sensitization of officers on the effect of the human rights violations to avoid new cases, lobbying for more funds to clear the existing areas, among other measures. 2.5, prison decongestion. The government has undertaken a prison decongestion program in prisons under Article 121(4)(b) of the Constitution. The President may, on the advice of the committee, grant a person a respite, either indefinite or for a specified period, from the execution of punishment imposed on him or her for an offense. On 22nd April 2020, His Excellency the President of Uganda pardoned 833 prisoners countrywide through the prerogative of mercy as a measure against the spread of COVID-19, the coronavirus, by decongesting the prison facilities. On 3rd January 2022, 78 Ugandans and 1 Venezuelan were pardoned. On 20th August 2023, the President of the Republic of Uganda pardoned 200 prisoners on public health and humanitarian grounds. And most recently, on 17th January 2022, the President of the Republic of Uganda pardoned 13 prisoners. 2.6, alleged violations. The November 2020 riots. Public riots and demonstrations occurred in Kampala and other urban areas, resulting in 56 deaths. Security and law enforcement agencies managed to counter the rioters and restored public order. The incidents of November 2020, which led to the loss of life, are regrettable. It should, however, be noted that the events of November 2020 were not peaceful demonstrations or assemblies, but rather violent, premeditated, and organized riots. The defiance of some of the political leaders to observe COVID-19 measures accounts for the riots. In a display of impunity, the politicians repeatedly stoked fear and incited violence that culminated into the violent riots of November 2020, which was a danger to the security and stability of the country and its citizens. Negotiations and compensation of the individual victims of the riots is ongoing to date. A number of compensation claims have been presented to the Office of the Attorney General by families of the victims. Whereas some have opted to obtain redress through court, as government, we are looking into these cases with a view to having them appropriately resolved. The government remains committed to ensure that every life that was lost in these unfortunate events is investigated and accounted for. Furthermore, the government did not in any way inspire or instigate these unfortunate events that resulted in 2 casualties of both rioters and security men and women that were seized with quelling the riots. 2.7, alleged abductions by government. The government strongly protests the offensive allegation that government abducts the citizens of this country. It is derogatory because the government does not abduct, but rather arrests people for various reasons as enumerated under Article 23 of the Constitution. Allegations that government abducts people is to impute that the government leads someone away by force or fraudulent persuasion. Government cannot rule out the fact that the word abduction is being misused since most of the allegations have been investigated. Government arrests suspected criminals and has not abducted nor does not abduct any person. An arrest undertaken by a police officer cannot in any way turn into an abduction. government has taken time to scrutinize the list of allegedly abducted persons submitted by the various security agencies, and we found that some of the alleged abducted persons were arrested and are undergoing prosecution over various criminal charges in the competent courts of law. Some of the alleged abductees belong to the newly formed rebel outfit called Uganda Coalition Force for Change. The Uganda Coalition Force for Change shadowy rebel group carried out attacks on security forces in Wakiso, Busunju and Kiboga between 25th November 2021 and 7th December 2021, during which 4 policemen were killed, 2 UPDF soldiers injured, and 5 guns taken by the attackers. Security forces reacted and arrested 23 of the group's members, all of whom were charged, arraigned, and remanded. 5 guns were also recovered. The rebel group leader, Ewan Ndugwa Semogere, was also later arrested and charged and presented before court. Government is committed to account for every single life of its citizens. Uganda is, however, mindful that some people in conflict with the law may deploy political tactics as a defensive measure to evade criminal liability and justice, which may occasion a miscarriage of justice. Mode of effecting arrests. The manner of arrests may differ depending on the circumstances of each case. Police and sister security agencies have different methods of effecting arrests, and this depends on the type of crime, attitude of the suspects, and nature of the environment. Indeed, due to the evolving nature of crime to sophisticated levels owing to technological advancement, sometimes the government may be compelled to effect arrests using plain-clothed officers, vehicles with civilian registration number plates, and other unconventional methods of arrest to keep pace with the ever-changing criminal tactics. This should only be used for purposes of camouflage in exceptionally fluid cases where the suspects are on high alert of possible apprehension, and therefore the risk to effect an arrest in uniform and with police vehicles would increase the probability of the suspects eluding arrests. Even where this method is used, the security personnel are still compelled by law to detain the suspects in gazetted detention centers and to inform the suspects of their rights in accordance with Articles 23, protection of personal liberty, and 28, the right to a fair hearing of the Constitution. However, we cannot rule out some criminal elements who may take advantage of some loopholes to indulge in acts of kidnap and abductions. That is why we encourage all persons to immediately report any such cases to the nearest police stations other than political leaders, because not all such arrests are conducted by the state. Available remedies for the alleged abductees. In the event that the right to liberty is interfered with contrary to the law, Articles 20 restraint to compensation from the responsible person or authority where it is the state, an agent of the state, or a private individual. Additionally, we reaffirm that the right to an order of habeas corpus is non-derogable and inviolable, and therefore cannot be suspended. Article 44D prohibits derogation from particular human rights and freedoms, inclusive of the right to an order of habeas corpus. Further, Section 25 of the Police Act, Cap 303, gives any person the leeway to apply to a magistrate's court for the release of any person detained beyond the permissible time limits. There are claims that some alleged abductees' whereabouts are unknown. This is currently a matter before the courts of law via miscellaneous cause number 1015 of 2024, Chivalama John Bosco and 29 others versus the Attorney General. The government established a standing committee on human rights, chaired by the Minister of Justice and Constitutional Affairs, which is mandated to handle human rights matters at a strategic level. The ministers responsible for justice, defense, security, internal affairs, and the Attorney General are among other members to this committee. We encourage colleagues in this House to bring to the attention of government any human rights concerns. The government established the Human Rights Commission as an independent body with a mandate to independently investigate any violations of human rights. This Parliament also has a Human Rights Committee intended to provide oversight over the human rights situation in the country. Pre-trial detention. The government has continued to ensure that only persons charged before competent courts of law are detained in prisons, and every suspect has a commitment warrant in accordance with Section 58 of the Prisons Act of 2006. No person is detained in the Uganda Prison Services without a commitment warrant, as indicated in Section 58 above. 2.9. The damage caused by indisciplined nomads known as Balaro. The Balaro claim to have bought land in the northern Uganda. In northern Uganda, land is mostly communally owned, and nobody can legally sell it without the permission of the clan or family. Secondly, even when land is legally owned, cattle strays and tramples on people's crops when land is not fenced and or does not have water. His Excellency the President banned the illegal presence of Balaro in the northern Uganda districts and directed that a law criminalizing nomadism is drafted under the Executive Order number 3 of 2023 under Order 5 of the Executive Order. Following the issuance of the Executive Order, a subcommittee of Cabinet chaired by the Right Honourable Prime Minister, constituting the Honourable Ministers of Land and Housing and Urban Development, the Honourable Minister of Internal Affairs, Honourable Minister of Agriculture and Animal Industry and Fisheries, the Honourable the Attorney General, and the Honourable Minister for Northern Uganda, was constituted to study the matter and implement the Executive Order. The Directorate of First Parliamentary Council has drafted the Animal Health Diseases Bill 2023 in accordance with the principles approved for the drafting of the bill under Cabinet Minute 257 2022 and in compliance with the Executive Order number 3, authorizing movement of animals upon obtaining a movement permit and criminalizing the movement of animals without a movement permit. Provision has also been made to allow the Minister to prescribe by regulations the conditions for issuance of a movement permit, including the time of movement of animals, proof that land where animals are to be settled has been legally obtained, proof that the said land has been fenced, and proof that a water source has been provided. The Animal Health Diseases Bill 2023 was submitted to the Ministry of Agriculture, Animal Industry and Fisheries for the onward transmission to Cabinet for approval. The bill, if passed into law, shall protect, preserve, and reinforce the right to property under Article 26 of the Constitution. Kasese Secondary School killings and abductions. On the 16th of June 2023, an act of violence transpired in Impondwe town within Kasese district as rebels affiliated with the Allied Democratic Forces, ADF, launched an assault upon Rubiriha Secondary School. This reprehensible attack culminated in the tragic loss of 44 lives, among whom were 38 students. Additionally, the assailants inflicted extensive damage upon property, pillaged essential food supplies, and perpetrated the abduction of 7 students, leaving others grievously wounded and in critical condition. In response to this heinous act, the government of Uganda swiftly initiated measures to address the crisis. Security measures were heightened within the border district to fortify defenses and facilitate the pursuit of the perpetrators responsible for this reprehensible assault. As a result of the concerted efforts by the law enforcement agencies, a total of 20 individuals suspected of colluding with the assailants were apprehended. These apprehensions signify a pivotal step towards bringing the perpetrators and their collaborators to justice, thereby upholding the rule of law and the fundamental human rights envisaged in the Constitution. The government of Uganda has offered 5 million shillings as compensation to each of the families of the victims who lost their lives, and a sum of 2 million shillings each to each of the victims who were injured during the attack. Investigations into the violations of human rights, in particular the right to life and property, by both the Uganda Police Force and the Office of the Director of Public Prosecutions, are ongoing with the intention to prosecute the perpetrators. In conclusion, although there have been some incidences of human rights violations in the country, government is committed and has put in place measures to uphold the fundamental human rights of all people within its jurisdiction, in compliance with the Bill of Rights under Chapter 4 of our Constitution. This is intended to ensure that there is peace, security, and socio-economic development of the country. I thank you. I beg to submit for God and my country. Signed, Kafuzi Jackson Karugaba MP, Deputy Attorney General. Thank you, sir.
Chair, one, I thank my colleague, our Deputy Solicitor General. That is our presentation, and I believe it answers your queries. Thank you.
Thank you very much for an elaborate